crazy decision out of the state of Colorado in the Rocky Mountain gun owners versus Polis case. You're not going to believe this crazy decision from the senior judge, whose experience, by the way, includes being, among other things, the deputy director of the Peace Corps in Calcutta, India, and Turkey. Obviously, critical credentials, and now we see the consequences of these credentials in his screwing up entirely of our Second Amendment right to keep and bear arms. But he was a Jimmy Carter appointee, so not a big shock here. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of The Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Amazon if you don't have a copy yet. All right, Rocky Mountain gun owners versus Polis. This is a decision out of the state of Colorado involving a request to enjoin on a preliminary basis the 3-day waiting period that's imposed by the state. We're not going to get into that specific law per se. We're just going to laser focus on the decision by senior federal district court Judge John Kane, an appointee to the federal bench by none other than President Jimmy Carter. That's right. So he's a senior judge on the federal bench whose credentials that helped earn him this place on the federal bench, such as working as a public defender, working in the Peace Corps in Turkey, in India, among other things, and also serving as a visiting lecturer in Dublin, Ireland, among other things. Nevertheless, with these credentials, perhaps you should have spent less time worried about foreign countries and more time worrying about our country in America and learning about something called the United States Constitution. Because for all his edumacation overseas, he doesn't have enough edumacation here in America if you look at his decision misapplying the Second Amendment. Now, keep in mind, this is not a heavy lift. So under Colorado's law, you have to have a waiting period that you have to wait before you can actually take possession of your firearm. We don't need to get into the details, but here's the thing. What's interesting about this is that Judge John Kane's decision misapplies the Second Amendment because he claims that the right to acquire a gun is somehow not part of the text of the Second Amendment. Now, as you know from the Bruen decision, and also from Heller, of course, Heller and Bruen are really the same thing. Bruen just, of course, clarified Heller for the lower courts that kept screwing it up and helped in a sippy cup fashion in Bruen teach them how to do the Heller case in a paint-by-numbers way because the lower courts kept screwing up Heller. So Bruen came along and tried to clarify that. And as you know, under basic Second Amendment interpretive law, meaning how do you interpret and apply the Second Amendment if you're a federal judge, or any judge for that matter, you start with the text of the Second Amendment, which reads in the operative language, the right of the people to keep and bear arms shall not be infringed. Once the text of the Second Amendment is implicated by virtue of the conduct of the Second Amendment plaintiff, the person that wants to own the gun, has the gun, whatever it is, or the text of the gun control law, once that text is implicated, then the burden shifts to the government to come forth to show that their modern-day gun control law is justified as a matter of long-standing historical tradition of firearms regulations in this country. Well, needless to say, it's not really going to be possible for the government to show once they get to the historical level. The government is not going to be able to meet its historical burden, as far as I can tell, that a waiting period before you can acquire a firearm or ammunition is constitutional. So the key is, of course, remember we've talked about this, the key is, of course, you want to shift the burden as fast as possible to the government to force them to come forth with historical analog laws. They have to be laws on the books at the time of the founding, 1791. The Second Amendment was adopted to come forth to justify their gun control laws. But what we're seeing is a lot of efforts by the anti-gun lobby and anti-gun judges. And I don't know if Judge John Kane, a Carter appointed to the bench who spent much of his early career in overseas countries. I don't know what the Second Amendment right to keep and bear arms is in Turkey, or the right to keep bear arms is in India. I'm guessing it's not very robust. With that said, it's what's going on is that judges such as Judge Kane are trying to elevate the entire dispute involving a Second Amendment challenge into the text where the burden is arguably upon the Second Amendment supporters to show that the text has been satisfied. So that's why they work really hard to try to shift everything into the textual fight. And we've talked about this on the channel before. And again, the reason why the anti-gunners want the entire legal fight to occur at the textual level of the Second Amendment is because, again, the burden is generally on the Second Amendment plaintiffs to establish the text is implicated. Because once the text is implicated, again, the burden shifts to the government, and then the government has to do a lot of work. So to avoid the problem of government having to do a lot of work and the problem of the government actually having to come forth to justify their modern-day gun control laws, which is very difficult for them to do, because in 1791 there were not a lot of gun control laws, which of course makes sense if you think about it, because why would you have a lot of gun control laws interfering with the freedom of the right to keep and bear arms in 1791, at the same time our founding fathers were adopting the Second Amendment, where they viewed that the right to keep and the right to peaceably carry firearms was a fundamental constitutional right. So you would expect there to be very few gun control laws at the time we adopted our Second Amendment, because it was viewed as a right. Okay? Now, it's the anti-gunners that are trying to rewrite all this history, but I don't think they will be successful if people are ultimately honest. So with that said, that context of the fight at the text is where the anti-gunners want to go, and they never want the burden shift to the government. Let's take a look here in this particular case. What did Judge John Kane do? The senior judge in the U.S. District Court for the District of Colorado, appointed to the federal bench by none other than President Jimmy Carter. I kid you not. Well, of course, he made the entire debate about the text, which is what anti-gun judges always do. So Judge Kane writes, for example, the relevant conduct here is therefore not covered by the plain meaning of the terms keep and bear in the Second Amendment. Seemingly recognizing this fact, plaintiffs contend the right to keep arms necessarily implies the right to possess arms one has acquired. And he goes on to talk, but again goes on to say that the relevant question is whether the plain text covers that specific means, i.e. the acquisition of guns, and it does not. Now, this is clearly wrong, okay? Now, I think if I were a professor of Judge Kane here, and he submitted this paper to me at one of my universities, I would say the following to him. I'd say this is a good first draft, but you have not dealt with a critical part of the text of the Second Amendment. Specifically, how do you square two things? One is that historically under constitutional law, you have what are known as ancillary rights, which are rights that are necessarily implied by the text of the Bill of Rights. So, for example, some basic examples, the First Amendment right to free speech necessarily implicates like the right to be able to buy paper, pens, and pens and pencils, the right to buy, let's say, a typewriter or a computer, the right to print and sell newspapers, the right of access, let's say, to the public square so you can, protest and seek redress from the government. None of the words that I've just used are found in the text of the First Amendment's right to free speech, or the First Amendment's right to a free press, or the First Amendment's right to freedom of assembly, or to seek redress from the government of issues you have. Nevertheless, these are all things that are clearly protected by the text of the First Amendment because they're necessarily implicated. I think the best example of this, that's easiest to understand, is if you look at the U.S. Supreme Court's decision in 1983. Now, I like the Minneapolis Star case from 1983, which is the name of this case, Minneapolis Star, because it involves a tax on ink. And the Supreme Court in 1983 concluded that this tax on ink was indeed a violation of the First Amendment, even though the word ink does not appear in the First Amendment anywhere on the text, nor does the word printing, for that matter, or the word paper, or the word, brochures or pamphlets or any of these things, or even books for that matter, right? There's no reference to paper or books in the text of the First Amendment, but obviously we understand that these things are protected necessarily, and this is a very, very basic rule of constitutional law. Often they're referred to ancillary rights, and ancillary rights are, again, things that are necessarily implicated by the text of the Bill of Rights, whether it be the First Amendment, the Second Amendment, the Fourth Amendment, the Sixth Amendment, it doesn't matter. Another example is the Sixth Amendment, right to counsel, obviously implies that you have the right to pay for your own lawyer if you want, or if you're indigent, then the government has the obligation to provide you with an attorney in a criminal case. None of this stuff is found in the text of the Sixth Amendment's right to counsel, but it's necessarily implicated, and the Supreme Court has repeatedly said so. So when it comes to the First Amendment, when it comes to the Second Amendment's right to keep and bear arms, obviously, at the most basic level, there's no doubt that the right to keep, which means to possess, and the right to bear, which means to carry, presupposes that you necessarily have the right to acquire the gun, either by making the gun or buying the gun. So that alone implicates the text of the Second Amendment, because it's necessary in the same way that you have the right to acquire ink to print a newspaper under the First Amendment that the Supreme Court talked about in Minneapolis Star in 1983, so too is the right to acquire firearms and ammunition necessarily implicated by the text of the Second Amendment's right to keep and to bear arms. Okay? But beyond that, if Judge Kane came back to me from his trips from Turkey and India to try to study American law and the U.S. Constitution, I would sit him down as a mentee and say, look, tell me how you deal with the word infringed. And then I would have him look up the word infringed. I would specifically have him look up the word infringed in founding era American dictionary. Specifically, I would have him look at the dictionaries compiled by that early American lexicographer, Noah Webster. Okay, we know Webster's dictionary, it all comes from Noah Webster. Or I would have him look up the dictionary of Samuel Johnson, the English lexicographer who hated Americans, by the way, but he was a big Tory, set that issue aside, he was a big English guy. But again, if you look at Samuel Johnson's dictionary or Noah Webster's dictionary at the time of the founding, they define infringed, and this is the key, because it's the right of the people to keep and bear arms shall not be infringed. So I would have Judge Kane look up the word infringed in those two dictionaries to start with, and then it would turn out if he did that, he would find that the word infringe at the time of the founding means to destroy and or to hinder. Oh, to destroy or hinder, to destroy. Now, obviously, if I put barriers or restrictions or regulations or taxes or anything that makes it the least bit more difficult to acquire or access or exercise the right to keep, which means to possess, or the right to bear, which means to carry arms, I am by definition, at the time of the founding, using Samuel Johnson and Noah Webster's definitions of infringe, I am infringing on the right to keep and bear arms, because it's all part of the same sentence, right? The right to keep and bear arms shall not be infringed. Infringed is defined at the founding by all the major lexicographers. A lexicographer, by the way, is the person that compiles dictionaries. That's all it means. But all the major lexicographers at the time of America's founding defined infringe to hinder or to destroy. Now, a waiting period in the context of this case in Colorado may not destroy the right to keep and bear arms, but it certainly hinders it. It functions as a regulatory tax, a restriction, a delay. It's a hindrance. Now, maybe you could argue it's not a big hindrance, but that's irrelevant, because the text of the Second Amendment, again, the right of the people to keep and bear arms shall not be infringed. And if you define infringed as to hinder or to destroy, in this context, assuming a waiting period does not destroy the right to keep and bear arms, it certainly hinders it in the same way that a tax on ink would hinder the First Amendment's right in the Minneapolis Star case from 1983. Now, the reason why this is important, of course, is you understand this because I drive this in. I drive this in because I will make you smarter than anyone else in that room, including fancy PhDs from Oxford and Cambridge. I will make you smarter in that room than all of those people, okay, when it comes to the Second Amendment. Now here, once the text is implicated by the waiting period, which means it is a hindrance, it is a form of a tax, it is a delay, right? All of this is a hindrance. It means that the text of the Second Amendment has now been implicated. Implicated, okay? And why is that important? You know why. Because once the text is implicated by the waiting period law in Colorado, which it clearly is, the burden shifts to the government to do what? To come forth with a historical analog law or set of laws to show that since our America's founding, since the adoption of the Second Amendment, there's a long-standing tradition of waiting periods as a form of hindrance on the Second Amendment right that can thereby justify the modern-day waiting period in Colorado. That is not going to be doable, as I see it, at the historical level, which is why the anti-gunners and judges like Judge John Kane, assuming he's not simply not competent at applying American constitutional law, he didn't pick it up in Turkey or, Turkey or India, okay? But with that said, guess what? The text is implicated, the burden shifts to the government. The government has to step forth and come forth with historical analog laws. But again, as you know, Judge Kane said that the text of the Second Amendment is not implicated by the waiting period. And the reason why they do this is because they know that once the text is not implicated, they don't have to shift the burden to the government to do anything. We all basically lose at the textual level, but that is simply not the case. Okay. Now, two other quick things about this decision. There's a long decision here about a long discussion here about the Colorado Uniform Commercial Code, the UCC. We can get super geeky on this, but it's totally unnecessary because under basic constitutional law, state laws cannot override constitutional rights. A couple quick examples of this. Last term, you had that important case out of Minnesota dealing with the takings clause under the 5th and the 14th Amendment. That in Minneapolis law, I believe, I forget the county was it Halloran County or Halperin County? But anyway, it doesn't matter. But that Minnesota case out of one of the counties there that said that if you sell your house on a tax sale and there's extra money left over, the county said they were entitled to that property under state law, but the U.S. Supreme Court came out and says, no, it doesn't matter what state law says because the Constitution says that property belongs to the property owner in the case there of the older woman who owned the house, and there was enough money after the sale of the house to satisfy the tax debt and the penalties, and the remaining amount was to go to the property owner and not to the county. So then the point is, any discussion of the the Colorado Uniform Commercial Code is irrelevant because this does not override the Second Amendment or the Constitution. Some creative arguments about the UCC, but you don't need to go there if you're litigating this case. All right, folks, I hope you learned a little bit something here today about the Rocky Mountain gun owners versus Polis case. Again, I think that the judge is clearly wrong. The Supreme Court would never approve of a decision that the right to buy a gun or to acquire a gun is not implicated by the text of the Second Amendment. It clearly is under basic Supreme Court precedent. Nevertheless, I'm not shocked that a judge with excellent legal training in India and Turkey did not quite nail the U.S. Constitution, especially somebody appointed by Jimmy Carter to the federal bench. With that said, I think this will get fixed in due course because it really does implicate the text of the Second Amendment. The burden will eventually shift to the state of Colorado to justify this gun control law, and I have no idea what historical analogs they're going to be able to pick to justify a waiting period. I'm not aware of any at the time of our founding, so we will see what happens going forward. And again, if you haven't subscribed to the Four Boxes Diner, make sure you do. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.